New York DWAI by drugs attorney Andrew Stengel. Driving while intoxicated tends to bring drunk driving to mind. It's true that most DWI charges in New York and other states relate to alcohol. In New York, it is also a crime to drive after consuming drugs or a controlled substance. New York calls this driving while ability impaired by drugs, or DWAI by drugs. The law reads, "No person shall operate a motor vehicle while person's ability to operate such a motor vehicle is impaired by the use of a drug." Under the law, a drug is considered anything listed under the 5 schedules of controlled substances, some of which are available by prescription like pain or sleeping medications, and other are outright illegal like marijuana or ecstasy. The most common drug associated with DWAI by drugs arrests in New York is marijuana. DWAI by a combination of alcohol and drugs. Another section of New York's vehicle and traffic law states, "No person shall operate a motor vehicle while the person's ability to operate such motor vehicle is impaired by the combined influence of drugs or of alcohol and any drug or drugs." Driving under the influence of prescription drugs. The authorization by a doctor's prescription to take a drug or controlled substance is not a defense to DWAI by drugs in New York. The prosecutor's burden of proof in DWAI by drugs cases. As in any criminal case, the prosecution has the burden of proving DWAI by drugs beyond a reasonable doubt. That means proving beyond a reasonable doubt that a person's ability to drive was actually impaired to any extent by showing that a person did not possess the physical and mental abilities a driver is expected to possess in order to operate a vehicle as a reasonable and prudent driver. That is a high standard, and it is sometimes difficult to meet in a driving while ability impaired by drugs cases in New York. Prosecutorial challenges and evidence in DWAI by drugs cases. The evidence of DWAI by drugs cases varies widely. In some cases, the evidence of alleged impairment by drugs may be the driver's own admissions to the police about taking a drug. Police may find marijuana or a controlled substance on a person who is arrested or in the car. Police may also base their arrest on the observations of impairment by the driver. In still other cases, the evidence of DWAI by drugs may be from a blood test. Evidence in DWAI by drugs cases. The performance of coordination tests, which are videotaped in New York City. The performance of standardized field sobriety tests, which are more often conducted by police outside of New York City. Recovery of a drug from the car, a blood test, observations of the police officer, including watery and/or bloodshot eyes, slurred speech, unsteadiness on feet, odor of marijuana. DWAI by drugs penalties in New York. First offense: up to 1 year in jail, a fine of up to $1,000, 6-month driver's license revocation. Felony DWAI by drugs penalties in New York. A driver will be charged with felony DWAI by drugs if the driver has a prior DWI conviction in any state within the previous 10 years, or there is a passenger in the car who is 15 years old or younger. Felony DWAI by drugs is punished by a Class E felony with up to 4 years in state prison, a fine of between $1,000 and $5,000, driver's license revocation for at least 1 year. As a former prosecutor and current criminal defense attorney in New York, Andrew Stengel has aggressively and successfully handled hundreds of alleged DWAI by drugs cases, whether the drug is marijuana, a prescription medication, or a controlled substance. Visit the website of Andrew Stengel for more information. STENGELLAW.com, or send an email to info@stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.